The court's ready to hear argument in 2404. In re the Texas Education Agency, a petition for writ of mandamus from Travis County and the Third Court of Appeals District.
May it please the court, Mr. Heifel will present argument for the relator. The relator has reserved 5 minutes for rebuttal.
Thank you, Mr. Chief Justice, and may it please the court. The legislature recently and definitively affirmed the right of a state appellant to supersede trial court orders. The trial court below denied Commissioner Morath that right. The Court of Appeals recognized the trial court's error, but then made the same mistake by continuing its injunction. This court should grant mandamus relief to preserve the legislature's policy decisions regarding supersedious and to allow Commissioner Morath to better serve HISD students. More than 50 years ago in Amex, this court recognized that supersedious is a policy decision that involves weighing competing considerations. There will often be, as in this case, a zero-sum situation in which the plaintiff alleges that it will suffer irreparable harm if the state is allowed to act, and the state, acting on behalf of the people, or in this case, on behalf of HISD students, alleges that there will be irreparable harm if the state is not allowed to act. And the question becomes, what do we do in that situation? Well, the legislature could have decided that a trial court's orders will always bind a state appellant pending appeal, or it could have left that to the discretion of the courts. Instead, the legislature has decided that a state appellant can always supersede a trial court's orders, except in a matter arising from a contested case, which of course we don't have here. The reason, perhaps, for the legislature's policy decision is that we don't want a subordinate governmental entity or a private litigant to be able to essentially filibuster state action for the months or years that it takes for the litigation to wind its way through the courts. And that risk is not just hypothetical, and this isn't the first time that the commissioner's hands have been tied by a lawsuit. So, for example, in our briefing, we discussed the Progresso ISD case. In that case, by suing the commissioner, the school district was able to delay state action by almost 4 years. That's essentially someone's high school career. And even though Commissioner Morath eventually prevailed, he wasn't able to turn back the clock and better serve those students during those lost years. Or take this case, for example.
Mr. Heifel, why should we treat what the Court of Appeals did under Rule 29 as effectively as supersedious rather than being an action rooted in Government Code 22.221 and the power of the court to preserve its jurisdiction?
A couple of responses, Justice Busby. First, supersedious is a broader question that has implications that extend beyond the trial court level. So in Amex, this court recognized the broader policy issue: will the state be bound by the trial court orders or not pending appeal? And the court expressed skepticism about the authority of a court of appeals to issue this kind of temporary order in the teeth of a statute that guarantees supersedious. And more recently—
Mr. Heifel, on that point, you said that supersedious is broader, but isn't the word supersedious usually restrains the judgment creditor from executing on the judgment? So does supersedious speak to the power of courts or to the power of the opposing litigant to execute?
Your Honor, yes, Justice Flynn. The word supersede means to suspend the enforcement of the judgment. And so anything that acts to violate that right, to allow the judgment to be enforced, or in this case, to allow the temporary injunction to be enforced, acts contrary to the state's right to supersedious, as Chief Justice Frost recognized in the dissent in State versus Texas Democratic Party. Turning back to Justice Busby, to the second part of your question about Government Code Section 22.221A, that provision allows a court of appeals to issue a writ to enforce its jurisdiction. And as applied to this case, presumably that would mean to prevent the case from becoming moot. But we don't have the type of situation in this case, something like the demolition of a building. That is something that self-evidently and indisputably would moot the case. And whether the underlying case will become moot if this court grants mandamus relief is debatable for a couple of reasons. First, on page 9 of its brief, HISD asserts that the case would become moot because the commissioner would install a board of managers who would then have the authority to pull down the appeal. But even if we assume that the commissioner immediately and successfully installs a board of managers, we can't speculate as to what any of those individual board members might or might not do. And there's nothing in the...
As long as it's a possibility, though, that does seem to be a very strong concern. If it's a possibility, why isn't that enough? I mean, do we really need to speculate? They could do it or they can't. I don't know. It just seems like a real concern. What about that?
Well, Your Honor, again, we just don't know who those individuals are, what they might do, what competing considerations they might have for attempting to have the appeal dismissed or not. And it's too speculative.
You're saying, Mr. Heifel, that your office won't be arguing that the case has become moot because of any subsequent action if the board is appointed?
No, Your Honor. And that brings me to the second point about mootness. In the trial court, HISD also advanced another argument. It argued that the mere installation of the board, apart from anything that the board might do, might be sufficient to moot the case. And in making that argument, HISD relied on third court precedent, but it also indicated some disagreement with that third court precedent. And that's on pages 357 and 358 of the mandamus record. And there, the question involves ultra vires doctrine. And HISD has never conceded that the mere installation of the board of managers would be sufficient to moot the case. And that's a question that presumably will be argued and litigated in the third court and then in this court if a board of managers were to be installed. So again, there's nothing like the demolition of a building. And if this court were to deny mandamus relief on the basis of HISD's mootness argument, the court would have to hold that the installation of the board of managers or that the adjustment of the academic accountability status would moot the case. That holding could have implications for the pending interlocutory appeal, and the holding could also have broader implications for ultra vires doctrine. So the mootness analysis here is not as clear as perhaps HISD would have us believe. Going back to the legislature's policy decisions.
So just to be clear on what your position is, though, on mootness, your position is because it's not clear the court couldn't protect its jurisdiction in case it would become moot, that you don't think it is going to become moot, or I'm still not clear on that.
Sure. So our position on ultra vires doctrine is yes, it would become moot if a board of managers is installed, because once an executive officer takes that sort of action, an ultra vires claim is not the appropriate vehicle for challenging that. Again, HISD has not conceded that point and has indicated that it will presumably argue that point below. And I apologize, was there another portion of your question, Justice Busby? Thank you. Returning to the legislature's policy decision, that decision is now codified at section 22.004I. That provision is worded very broadly and indicates that no rule can interfere with the state's right to supersedious. Just like in Geomet, this court held that the statutory right to an automatic stay is not subject to being trumped by Rule 29.3. Similarly, the state's right to supersedious is not subject to being trumped by Rule 29.3, or the statute actually says, or any other rule. Again, it's worded.
But what about if Rule 29.3 is rooted in Government Code 22.221, though? How do we decide what happens if 221 points one way and 004 points the other way? How do we resolve that?
They might point in different directions if it were clear that the case were going to be moot. Even if the case, for the reasons we've already discussed, that mootness is a bit complex. But even if we assume that the case would become moot, that's best made as a policy argument to the legislature. One of the considerations that it might take into account is this risk to a litigant of the case becoming moot. But there's also, on the other part of the ledger, the risk of undue delay in interventions that the executive branch of the government has deemed to be necessary to protect school children or other Texas citizens. And
If without an order, the case would become moot, could the Court of Appeals issue such an order?
No, Your Honor, we don't believe that it could, because again, that's best left for the legislature to decide. But that doesn't mean that there's never any sort of check on executive action. The universe of executive officials who are entitled to this absolute right of supersedious that we're discussing is fairly narrow. It's only the entities who are described in section 6.001 B1 through 3 of the Civil Practice and Remedies Code. In other words, the state, a department of the state, or the head of the Department of a state. Those individuals are generally going to be subject to this court's original mandamus jurisdiction, either exclusive mandamus jurisdiction under 22.002C of the Government Code, or non-exclusive original mandamus jurisdiction under section 22.002A, depending on the executive official. In addition, the court should...
Could the Court of Appeals use Rule 29.3 to enter an order that is similar to the trial court's injunction, but not the same? So it's a different order, but does some of the same things, but it can't plausibly be characterized as reinstating the trial court's temporary injunction. Would that be permissible?
If the Court of Appeals order is sufficiently distinct that there's no plausible way to characterize it as continuing the trial court's injunction, then that would be permissible because it wouldn't interfere with the state's supersedious right. Here, what
that seems like that's an odd result, right? If the Court of Appeals is generally empowered to enter orders preserving the party's rights that give the plaintiff some of what it's asking for temporarily, it can do so, but it can't do its discretion to do so is limited by a rule that the injunction it enters cannot look just like the injunction the trial court entered. Well, that's sort of an odd place for the Court of Appeals to be in.
Your Honor, the definitive question is, what was the trial court's order that was superseded, and what does that order prevent the state from doing? So here, for example, we have an injunction. It prohibits the commissioner and the TEA from taking certain actions. To the extent that the Court of Appeals order interferes with that right, then it's not a permissible exercise of discretion. To the extent that the order might do other things that don't interfere with that right, it would fall under the Court of Appeals general authority. And to be clear, we're not questioning as a general baseline matter the authority of appellate courts to issue orders to protect parties' rights or to protect their jurisdiction. We're only discussing what happens when that general authority comes up against section 22.004 and rule 24.2A3. And in analyzing that, the court should also be mindful of the fact that the concerns that this court expressed in dicta in In Re State Board for Educator Certification are no longer in play. In that case, there was an individual involved in a contested case in an administrative proceeding, and this court expressed concerns about what if the state revokes his professional license? How is he going to make a living during the course of the appeals? Now, section 22.004I and rule 24.2A3 both include an explicit exception for that type of a situation, so that the concerns the court expressed there are no longer in play, no longer operative.
Mr. Heifel, if HISD had brought this as a mandamus, as you suggested, then would the court be able to use 22.221 to enter an order to preserve the party's rights, or what's your position on that?
Your Honor, the procedural vehicle doesn't matter, but the type of relief that the party is seeking does matter. And Chief Justice, I see I'm out of time. May I finish the question? If the purpose of the mandamus is merely to decide whether to continue the trial court's injunction, in other words, if it were the same thing the Court of Appeals did here, but under a different name, that would not be permissible. However, if the mandamus, either in the Court of Appeals or perhaps an original mandamus proceeding in this court, was to actually address the merits and the legality of the state officer's actions, that would be a different situation. And we're not contesting the authority of the court to do that. It would have a different standard, and it would be analyzing different issues, and it would not merely be infringing on the state's right to supersedious. If there are no further questions, I'll reserve the remainder of my time.
Any other questions? Thank you, Mr. Heifel. We'll hear from the real party.
May it please the court, Mr. Campbell will present argument for the real party in interest.
May it please the court. It is an honor and a privilege to be before the court today, both to defend this court's rule, which the court adopted and put into 24.2A3, and also to defend really the authority of courts in general in Texas, both trial courts, courts of appeals, and this court, to issue orders both to protect their jurisdiction and also to exercise their plenary jurisdiction over matters that are before them. Those fundamental matters are before the court, but Justice Busby, I think you put your finger on the heart of this case and the easiest way for the court to resolve this case when you asked my friend on the other side about 22.221. Because of course, when the legislature enacted the statute in this case, the legislature used the term supersedious. And as we have described in our briefing and as clear in the tab 1 of the bench book that we provided with the court, the term supersedious is a term that is traditionally understood to apply to what a trial court does. While courts of appeals generally and typically review supersedious orders, that is the language that the language typically applies to trial courts. And this court certainly saw it that way, as did the court's advisory committee, when it enacted a rule that clearly and indisputably applies to trial courts. Now, my friend on the other side says that this court enacted a rule, I guess made a mistake when it enacted the rule, and that it should have enacted a rule that applied to appellate courts as well. Our view is that the plain language of the statute itself supports this court's rule. But in addition, the rule that the state asked this court to adopt runs straight into serious constitutional concerns, as this court raised in questioning. I mean, Justice Guzman, you mentioned, of course, the fact that in this case, we certainly, it seems like it's undisputed that we have the possibility that the subject matter of the jurisdiction could be done away with, that this whole appeal could be mooted. And while I heard my friend on the other side argue that we have certainly raised some arguments questioning whether this appeal might be moot, the state has argued from day one in this case that once the commissioner puts a board of managers in place over Houston ISD, no court, this court, appellate court, trial court in Texas can review that action. That is the position that the state has consistently taken. And I could point you to numerous places in the record, but if the court just looks at the plea of the jurisdiction that the state filed, which is being considered by the third court, along with the temporary injunction that was entered in this case. In that plea to the jurisdiction, the state took the position that that once the board of managers was put in place, no court can review that. That's a final unreviewable decision. And yet the state also took the position that we couldn't challenge it before it happened because it wasn't ripe. Now, of course, the reason that we challenged the decision before the commissioner decision became final was because of the Progresso ISD case that my friend on the other side mentioned. Now, in that case, he claims that that was an example of a filibuster. Nothing could be further from the truth. The Progresso ISD case involved ultra vires unlawful action by the commissioner. If you look at the Third Court of Appeals opinion, the Third Court assumed without deciding that what the commissioner had done was ultra vires, and yet because he had already done it, the court felt that its hands were tied and it could not do anything. That case, however, was involved in multiple proceedings, and a proceeding went forward in the trial court. And in fact, the trial court entered a judgment, a detailed set of findings of fact and conclusions of law, explaining why the commissioner had committed ultra vires acts in that case. The reason that that case did not end up going to a final judgment on appeal is because weeks before oral argument, the parties were able to reach a resolution in that case. Progresso ISD is not an example of a filibuster. It's an example of really a success story, in that although the commissioner attempted to commit ultra vires acts, ultimately the commissioner and the school district were able to work out a mutually agreeable compromise. Justice Blacklock, you had mentioned that it didn't seem to make much sense that we would ask a court of appeals or criticize a court of appeals for entering a temporary order under either 29.3 or the court's inherent authority that is similar, if not identical, to the temporary injunction. And I would say that is not only unsurprising, but as you'll note in our brief, I think it's footnote 13, we cited a slew of cases where that is the general practice. And that is because there's no dispute in this case that the Court of Appeals properly has jurisdiction to review the temporary injunction in this case. And so we cited, I think, at least a dozen cases where the standard practice in Texas courts is that when a temporary injunction is denied and appealed to a court of appeals, even though the trial court denied the injunction, in order to preserve the appellate court's right to review the injunction, courts of appeals typically enter those temporary orders to leave it in effect so that the court can review the injunction. Now, in this case, of course, we showed the trial court that we were entitled to, that we had a probable right of success and that we were threatened with irreparable harm. The trial court weighed those considerations and entered the injunction. And all that the Court of Appeals has done here is leave that in effect so that it can consider the appeal that the state filed. At its heart, I mean, the state's argument presumes that the state can somehow file an appeal to evade review instead of to seek judicial review. All that Houston ISD seeks in this case.
When you're asking, excuse me, counsel, when the trial court denies a temporary injunction and you're asking the Court of Appeals to give you one, should you be subject to the same probable right to relief standard that you normally would be subject to on a TI?
Justice Blacklock, I think that's exactly my point, is that the only way the Court of Appeals can analyze that issue is, of course, to get to the merits of the temporary injunction in its review. But in the cases that we've cited, what has typically happened is that until the Court of Appeals can review that temporary injunction on the merits, courts of appeal generally say without consideration of the merits, without reviewing yet whether there is in fact irreparable harm, whether there is a probable right, will enter the temporary injunction to preserve the court's jurisdiction. In fact, Justice Blacklock, if you look at tab 4, we provided the court with a petition.
Did you in this case, did your Rule 29.3 motion argue that you had a probable right to relief? Was that part of the basis for the relief that you got from the Court of Appeals?
I think so, Justice Blacklock. I mean, in the trial court, we had already demonstrated that probable right to relief. And that's really what the whole appeal is about. I mean, that is the merits of the appeal that is pending before the third court. The court has the brief from that case. And as you can see, there are a number of issues that have all been briefed thoroughly to the Court of Appeals. And if you look at our petition that's in the mandamus record, you can see that this was not a skeleton petition. This was a robust pleading where we detailed all of the facts and all the legal reasons that the commissioner violated the law and committed ultra vires acts in this case. Behind tab 4 of our brief, you'll note that there's a petition for writ of mandamus that the state filed in this course just last month. And the position that the state took in that case, where the state had lost a temporary injunction, where the Court of Appeals had not given it temporary relief, was that this court was required to, by mandamus, require the Court of Appeals to enter a temporary order preserving the temporary injunction that had been denied so that the court could consider it. And indeed, that is, I think, in line with what this court said in Amex. Amex is an interesting case that obviously is cited throughout the briefing. And as the court knows from our brief, we take a very different view of Amex from my friend on the other side. The state has pointed to part of Amex, the first of three analyses that this court went through, because remember that Amex was a mandamus to this court, asking this court to mandamus a court of appeals over a temporary order that court of appeals had entered. And so the first issue, as the state recognizes and properly informs the court, was about whether or not the legislature properly gave the state a right to automatic supersedious. And this court held there was nothing wrong with that. As this court noted in the state board education just a few years ago, of course, that automatic supersedious right is not an absolute supersedious right. But that's only one of three parts of that opinion. The second part of the opinion that I think is important for this case is the part of the opinion where this court analyzed the important constitutional and statutory right that courts of appeals have over the subject matter of their cases. And this court exercised reticence and judicial humility to say this appeal has been filed in the Court of Appeals. Whether or not we would agree with the decision the Court of Appeals made to enter a temporary order in this case, that is the Court of Appeals decision. Remember in that case that what had happened was the trial court entered a final judgment, and then in an apparent attempt to avoid the Court of Appeals acting, it entered a side temporary order to try to leave an injunction in place. And the Court of Appeals in that case wasn't happy about that, felt that it interfered with that court's jurisdiction, and entered an order to preserve that jurisdiction, that court's jurisdiction over that case. What is interesting in Amex, Eichelberger, and the line of cases that we've talked about in our briefs is that this court has consistently over the years recognized the inherent constitutional authority of trial courts, courts of appeals, and this court to protect jurisdiction over a case once it is given and to act within that jurisdiction. And in fact, if the court looks carefully at the Amex decision, especially the second argument, you'll note that the first paragraph of the discussion about the Court of Appeals authority talks about that plenary jurisdiction once the court's jurisdiction has been invoked. Clearly, the third court's jurisdiction has been invoked in this case by the state. And then the court goes on to recognize that in addition, the court certainly has the fundamental authority, as this court recognized in Geomet, to preserve its own jurisdiction.
Some of what you're saying about the court's authority to preserve its jurisdiction could be interpreted as an end run around the probable right to relief standard for temporary injunctions. Because if the court can enter what's essentially a temporary injunction just because the case might go moot or it otherwise might lose jurisdiction, then the relief sought has been obtained, at least temporarily, despite no showing of a probable right to relief, which you're sort of getting a temporary injunction without proving what you normally need to prove to get one. And do you think that's a problem? Do you see that tension there?
I don't see that as a problem, but it is particularly not a problem in this case, Justice Blacklock. Because of course, in this case, unlike the other cases I'm talking about where a party was denied a temporary injunction, in this case, we proved to the trial court that we were entitled to a temporary injunction. So we have already proven in the trial court a probable right of recovery. That decision by the trial court is currently under review by the third court. And it's telling in this case that the state has never asked the third court to expedite its decision. The state did file in the Court of Appeals a motion to expedite the Rule 24.4 motion. But if what the state really wants is an expedited decision of the case, then the state certainly could have filed a motion to expedite briefing. I think this court has certainly seen some cases recently with some very tight time schedules where that was necessary. In this case, the state has never done it. The briefing has proceeded, I would say, expeditiously. Both sides have asked for reasonable extensions, but the briefing has continued. And of course, this case was submitted to the third court back on September 1st. And the court could issue a decision on the merits, reviewing the trial court's findings on probable right to recovery any day.
Would
Mr.
that-
Campbell,
Would that moot this proceeding?
I think that might be a question better posed to Mr. Heifel. I don't think it would moot this mandamus, because I assume that the state would continue to make the same argument, that regardless of what the Court of Appeals decides, that it is still free from any kind of judicial review. But I'll leave that question to Mr. Heifel.
and Mr. Campbell, I was going to ask you, because sometimes parties file a motion for expedited decision in the Court of Appeals. Did the state do that?
They didn't, Justice Guzman. As I mentioned, there was a motion for expedited consideration of the Rule 24.4 motion, but in this case, the state never asked for expedited review of the briefing on merits or of the decision. And in my view, the third court has moved this case very expeditiously. I mean, it was set for submission, I think, within 8 or 9 months of the original notice of appeal.
Mr. Campbell, I think it's a given that when the legislature passes a statute, that statute will trump a court rule, whether it's procedure or evidence. Is it not so given? What is the answer in terms of whether a legislatively enacted statute trumps a court's inherent authority to protect its jurisdiction? Can the legislature deny a court by the inherent authority to protect its jurisdiction by enacting a statute?
No, Justice Boyd. And that is because Article 5, Section 1 gives this court and other Texas courts inherent authority to act within their jurisdiction. Certainly, there may be statutes where the legislature could act to limit certain courts' jurisdiction, assuming that doesn't run afoul of some other constitutional or statutory provision. But once a court has jurisdiction over a matter, it would violate Article 5, Section 1, in addition, potentially the Open Courts Clause for the legislature to do that. And this statute is an interesting one, right? I mean, this is an interesting statute because the state talks a lot about statutes trumping rules, but this is a statute that expressly invoked this court's rulemaking authority and asked this court to enact a rule. And so in our view—
And yet we do recognize that the legislature is empowered under the Constitution to limit and restrict even our jurisdiction. I mean, up until recently, there had to be a conflict in the Court of Appeals for us to be able to exercise jurisdiction. We have no jurisdiction to conduct factual sufficiency reviews. I mean, there are legislatively imposed limits on our jurisdiction. I'm not sure why just conceptually why the legislature wouldn't have the same power to limit the Court of Appeals jurisdiction over the appeal in this case.
Justice Boyd, our view is that conceptually the problem with that is that it would attack constitutional protections that are both, really, I think that are inherent to separation of powers. I mean, I had mentioned Article 5, Section 1, but I guess I would go back to what this court said in State Board of Education and note that there's also, I think, a problem in Article 2, Section 1, if the legislature in an area where the court has jurisdiction can prevent this court from acting. And I think it's particularly true in this case. I mean, the state has seemed to indicate that because the state is involved, that should ameliorate constitutional concerns. I actually think that in the context of an ultra vires case where a state official is acting unlawfully, that the constitutional concerns are heightened. And of course, when constitutional rights are at stake, courts can't automatically defer to the judgments of other departments of the government. And that's the argument that the state is making, that it has an absolute unqualified right to commit ultra vires unlawful acts that prejudice another party. And the irony is that under the state's rule, if there's no irreparable harm, then the suit could proceed. It would only be in lawsuits where the ultra vires or other unlawful act of the state official causes irreparable harm, that there would be no judicial review. That can't be right.
But the difficulty in that, just conceptually, is then the legislature can pass a statute that trumps a rule that prohibits a court of appeals from entering an injunction, but it can't pass a statute that trumps that same court of appeals from relying on its own inherent authority, when rulemaking itself derives from our inherent authority to some extent. It just seems like there's a pretty fuzzy line there between one and the other.
Well, and Justice Boyd, maybe that's why the better course for this court to take in this case is to rely on the fact that in this particular case, not only do we have the court's inherent authority, but the legislature itself has spoken in chapter 22.221 of the government code to recognize that courts have inherent jurisdiction. And so when the legislature passed 22004 subsection I, clearly the context of the statutory scheme the legislature put in place recognized that the legislature was not trying to trample on this court's or the courts of appeals rights. And also that the fact that the legislature hasn't acted since then to indicate any criticism of this court's rule further shows that what this court enacted as its rule is consistent with the plain text and intent of what the legislature did.
Any other questions? Thank you, Mr. Campbell.
Thank you, Mr.
Heifel, I believe you have 5 minutes for rebuttal.
Mr. Heifel, counsel argues that your position is essentially that you have an absolutely unqualified right to commit ultra-virus acts. You respond to that?
Yes, Your Honor, that's not correct. We do have an absolute right to supersede a trial court's orders pending appeal. That's the only right that we are asserting, and that's a right that the legislature decided against the backdrop of this court's decision in Ray State Board for educator certification. The legislature chose to double down on the state's supersedious right.
But if the action that cannot be superseded is ultra-virus, then the result is you're arguing that at least pending the appeal, you have the absolute right to act ultra-virus.
Pending appeal, that's correct, Justice Boyd. The appeal could be accelerated. And in addition, as we discussed in the earlier part of the argument, there may be other procedural vehicles that could address a situation where there truly is an action by an executive officer that courts believe will be irreversible. They're going to demolish the Alamo or something to that effect. There may be other original proceedings that can get to those merits quickly, and the court can issue a temporary order while it's considering the merits in that original proceeding. But that's in the context of an original proceeding, not in the context of the underlying appeal where the legislature has guaranteed supersedious.
So, Mr. Heifel, a long time ago, before you even thought about law school, appeals would take years at times. And so under your argument, these ultra-virus acts that you're allowed to commit, the state is allowed to commit during the pendency of the appeal could theoretically cause a lot of harm. And that rule seems to be problematic, that you could have an absolute, unqualified right to commit ultra-virus acts regardless of the irreparable harm.
And Justice Guzman, this court addressed that exact argument in Amex. The court noted that perhaps the legislature should be more protective of the substantive rights of litigants by limiting the state's ability to supersede trial court orders. The legislature could have done that, and it chose not to. It's also important to note that the HISD has not alleged the violation of any constitutional right or vested property interest here. It brings up separation of powers concerns and other constitutional concerns. In fact, HISD as a subordinate governmental entity can't accrue those kinds of rights against the state, as this court held in Honors Academy. And in Honors Academy, this court also pointed out that the legislature has tried to keep these kind of academic accountability decisions out of the courts altogether. The legislature does have the ability to a certain extent to structure the court's review of executive actions. It's done that through finality provisions. It's done that by attempting to keep within the administrative process disputes that don't involve constitutional rights or vested property interests.
Well, if the Court of Appeals decides the merits of this case, before we issue an opinion here, would the case before us be moved, the mandamus?
No, Justice Busby, not simply by the Court of Appeals deciding the case. Instead, the relevant time trigger is the issuance of mandate. 22.004I and the rule 24.2A3 speak to the ability to supersede the trial court's orders while the appeal is pending. Once the appeal is finally disposed of, in other words, a court's mandate issues, that's when supersedious would no longer be relevant. I'd like to briefly address tab 4 and tab 3 in the bench book that HISD filed just yesterday. Those tabs are a briefing from the state in the In re Hotze and In re state mandamus proceedings in this court. And there is no supersedious issue. In fact, the trial court denied the request for a temporary injunction, and so there was no order to supersede. In addition, the briefing only stands for the uncontroversial point that as a general matter, courts have the authority to preserve their jurisdiction, but again, what we're talking about here as an exception.
Any other questions?
If there are no further questions, we would ask that the court grant the petition and vacate the Court of Appeals temporary order.
Thank you, Mr. Heifel. The case is submitted and the clerk will adjourn the court.
Oh, yay, oh, yay, oh, yay. The Honorable, the Supreme Court of Texas now stands adjourned.